Contracts is the most difficult subject on any bar examination. Contracts problems are complicated. There are a ton of tiny little rules, just about every one of which it seems can be tested. And it's very difficult to answer a good essay question on contracts within time constraints. The good news is a clear analytical approach to contracts will make all of these problems a lot less severe than they would be otherwise. But for a moment, pause and consider the great importance of the law of contracts. Obviously, we know that contracts is a big deal because it's tested heavily on the multi-state with 34 questions, and it's also commonly tested on the essays. Not only that, but we can be tested on both the common law of contracts and the modern Uniform Commercial Code, which is designed to streamline transactions between merchants. So, there's a lot going on in contracts, but the problem is even more severe than that. Think about it for a moment. Contracts principles lie at the heart of agency law, of partnership law, of corporations and other business organizations, and contracts principles come up all the time in real property and even sometimes in wills and trusts. The basic principles of contract law are woven throughout many of the subjects on various bar exams across the United States of America. Understanding contracts and knowing how to think about contracts is central to your success on any bar exam in America. So, let's pause for a moment and think about how to think about contracts. The basics of contracts are very simple. We've got to establish whether or not there's a contract and the plaintiff is going to be seeking remedies. But a closer look at how the law of contracts causes us to structure our arguments is much more helpful. When we think about it, especially thinking about it from the perspective of the defense, we see that contract litigation follows a very standard format. And having that format in your mind will help you organize your thinking and organize your answers to contracts essay questions. So, the first thing that we've got to do as a plaintiff is establish the existence of a contract. So, step one to thinking about contracts is formation. Step two is defenses to formation. That's what makes contracts so complicated. The defense has got a number of different places in the analysis where it needs to be heard. So if we start with formation, the next step is defenses to formation. After that, the plaintiff has to establish a breach. And here, the law of breach is quite complicated. Think about it rather like the law of negligence. We know that in tort law, mere ordinary negligence is commonplace, but higher forms of negligence, like recklessness or even wanton and willful misconduct, also belong on that continuum. Well, here in the law of contracts, breach is similar to negligence in that there are increasing levels of breach, and we'll be studying all of those levels when we get to that section of the outline. So, we've got a plaintiff that has to show the existence of a contract. A defendant will try to deny the existence of the contract. The plaintiff then will try to establish a breach of contract, clearly indicating how severe a breach it is. Next, the defense gets another bite at the apple. The defendant may very well have defenses to breach. And then, next, the plaintiff has to have a prayer for relief, remedies. And we know in contracts, the two most common remedies are damages and equitable relief, which here is known as specific performance. When we get to consider remedies in this series of videos, you'll see that there are a lot of other specific remedies that apply to contracts. But the simplest way to look at remedies in contracts is to indicate that we've got damages on the one hand and specific performance on the other. And we know that specific performance can be broken down into elements. So, now thinking about the subject from the big picture, we know that the plaintiff has got to have a theory of liability, and that theory here in this subject is breach of contract. The defendant will have a defense to the formation of the contract. The plaintiff will allege breach. The defendant will have a defense to the breach. Then the plaintiff seeks remedies, here likely damages or specific performance, and the defendant will have a defense to remedies, often both a defense to damages and a defense to specific performance. So, as we think about how to organize our ideas on any given contracts issue, if it's a multi-state question, what we need to do is identify which part of this long, complicated outline is being tested. Then narrow our focus until we reach the area of law which is actually being questioned. On an essay, we are likely to be called on to create a more narrative answer that reports on the facts of the pattern and analyzes them through a reasonable legal format. And this approach that I've suggested, formation, defenses to formation, breach, defenses to breach, remedies, and defenses to remedies, is the most comprehensive approach that you could have for the subject. And when you think about it for a moment, it's actually quite simple. The subject itself is complicated, but the way to think about it isn't. Just as is the case in all of the other subjects involving civil litigation, the plaintiff has to have a theory of liability. The defendant will have a defense to the theory of liability. The plaintiff has to have a prayer for relief, and the defendant will oppose that prayer for relief. That's really the shortest and most complete nutshell of contracts that you could hope to hear. Now, how is contracts tested on the multi-state? We've got a long, elaborate outline, and the examiners tell us that 60% of the questions on the multi-state will deal with contract formation, with conditions, and with remedies. And that leaves 40% of the questions to come from everything else on the outline. So we see that contracts is tested comprehensively, and a reasonable balance is presented in how they test it. Basically, they're going to test us on all of it every time. So we need to understand how the material is tested, and then we're going to focus carefully on each one of these details. This is a subject that I think will benefit greatly from an approach of divide and conquer. The outline that I'm presenting to you is basically the National Conference of Bar Examiners outline with a few minor alterations and annotations. As you go through this very complicated area of law, no doubt you will see little details that you'd never even heard of before, much less never studied before. I encourage you to annotate your outline, but do so judiciously. It's tempting to get lost in the vast quantity of details that are available here in the law of contracts. As you practice, you'll see that many, if not most of the issues in contracts are tested ritualistically. In other words, they ask strikingly similar questions over and over again. So, as you practice, keep track of your mistakes, annotate your outline to help you sharpen your knowledge of law, and relax. By having a clear way to think about the law of contracts, you're likely to be several steps ahead of a substantial percentage of the people that you are competing with. Next, we will go through a series of videos on the substantive law of contracts. First up, contract formation.